When they start, turn your camera out when they.
Good morning, everyone. Hope you all are well this morning.
Good morning, Your Honor.
Good morning, Officer Milton. Hope you're well.
Same to you.
Good morning. How we doing?
Good morning. Where would you all like to start this morning?
Start number one, Mr. Baggett. That's going to be a negotiated plea, Judge. Baggett. I'm sorry, that's going to be a bond hearing. Baggett, please. Baggett.
While we're starting, yes, Officer Milton.
After position one, we're gonna do, can we do position add-on one, Ms. Barlow?
I believe that's going to be well, I have down that as an MH reset. Is that accurate?
That's correct.
Okay, so she's going to be reset to an MH court. Do we have a date that we'd like to reset it to?
I'm not sure if she's already been scheduled. We have the other add-on, or one of the other add-ons was also the same announcement. but we put on for today to see if there was housing. But I'm not sure if that's the case with her. If she has a date already, or if we just need to put her on the 23rd.
Good morning, Ms. Champion. Do we know, or Ms. Grace, good morning to you both. The first available MH court that we can get?
Good morning, Your Honor. I'll check and see if she's already scheduled. If not, she can go on the 23rd.
Okay, very good. Thank you. So she's going to be rescheduled for MH court. So we don't need her any further this morning.
Okay, and one more question before we get started.
Okay.
For position 48, Miss Penny Mitchell. What,
That's a conflict attorney case. It's my understanding. Has a conflict attorney been assigned?
yes, she did speak to Attorney McLeod this morning, and I'm not quite sure.
Okay. We'll give attorney, if we can give Attorney McLeod a call to see when she's going to join us this morning so that we can get an update on all of her cases.
Thank you.
Okay. All right, so position number 1, Mr. Baggett, can someone tell me what the present bond is?
Yes, no bond, Judge. This was transferred from Superior Court.
Okay. Yes, Miss Evans, Battle, good morning. If you can give
Morning,
me,
Your Honor.
just give me the facts and the state's recommendation.
This appears to have happened March the 7th of 2026. This was out of East Point Police Department. They observed a black Chevrolet Malibu. The driver was not wearing a seatbelt. They were in a marked police vehicle, and they indicated that they turned their lights on. He accelerated at a high rate of speed. They observed to make a left turn on the Randall Street from Gus Thornhill Drive without stopping for a stop sign while attempting to catch up with the car and initiate the traffic stop. They also saw him turn left onto Lyle Avenue from Randall Street with disregard to a second stop sign, and then continue westbound on Lyle Street at a high rate of speed, disregarding a third stop sign while making a left onto Bayard Street. We're speeding through a residential neighborhood, disregarding multiple stop signs, attempting to evade police. They had auditable sirens going at the time, indicating that it was an emergency. He exited the vehicle at the fourth stop sign, and started running, and they were able to ordered him to the ground, drew their service weapon and ordered him to the ground. And at that particular time, he ran up to the front door of a residence, opened it, entered the residence, and shut and locked the door behind him. They set up a perimeter around the house. And eventually he exited the residence accompanied by a homeowner, which was a Colette Baggett. I don't know what the relationship is. And he was identified as the driver of the vehicle at the time. There was a female passenger in the vehicle who, as well as a 9-month-old child, that was not in a safety belt or restraining device within the car. And so I'm not sure of what his history is. I'm just trying to look
Get
through.
Ms. Hutcherson to provide that.
Okay.
Ms. Evans Battle.
And so basically just based strictly off of the charges that I have here, it would be a 5 We would ask for bond on the fleeing and attempting to elude. We would ask for $5,000 surety on that, 1,000 for the willful obstruction, and 1,000 for the child restraint, and 500 for the failure to obey a stop sign, 500 for the adult seatbelt violation. That would be our bond recommendation, Your Honor, at this time. No alcohol, drugs, or weapons while out on bond. Thank you.
Thank you. Ms. Hutcherson, good morning. Do you have Mr. Baggett's history?
Good morning. Yes, he has a total of 5 cycles. He has a conviction from April of 2025 for aggravated assault and riot in a penal institution. And then he has a conviction from October of 2023 for 2 counts of armed robbery, home invasion, false imprisonment, 3 counts of aggravated assault, and possession of a firearm or a knife during the commission of or attempt to commit certain felonies. And he did have a capital offense arrest in 2020 out of DeKalb, but there is no disposition on the GCSE about that case. And nothing
Thank you.
further.
Thank you. Mr. White?
Your Honor, he's been in jail now, 14 days with no bond on these charges. Well, I'm sorry, she's been in jail 32 days at this point with no bond. We would ask for a total of $4,000 bond. That would be $1,500 on the fleeing, and then 500 on the other 4 counts. Is that right? Anyway, we're looking at $4,000 total. We said he's already been in jail 32 days on these charges with no bond on at least some of them. And so he was currently employed before this happened with Titan Security. He has a family and significant ties to the jurisdiction. He's not planning on going here. He's got a mom, he's a son. Again, he's been sitting here 32 days with no bond. So ask for $4,000 total.
All right. So for the willful obstruction, it's going to be $1,000 good bond. For the fleeing, it will be a $4,000 good bond. For each of the other charges will be $100 good bond. Makes for a total of a $5,300 good bond. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Baggett.
Thank you, Judge. We'll be entering a waiver.
Okay. Mr. Baggett, your case will be returned to the division judge. You'll get notification of your next hearing date.
All right, next we got 2 through 4, Mr. Bateman.
And what are we doing with Mr. Bateman this morning?
Negotiated plea, Judge.
Very good, thank you. Good morning, Mr. Bateman. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down. Yes, Ms. Evans, madam.
Yes, Your Honor. This is a universal offer as to count 1, 12 months, serve 60 days, credit for time served, balance probated, complete an MHET, 12 weeks of anger management, no further contact with Yolanda Dowdy, stay away from the 953 Washington Street address. As to the count 2, it'll be 12 months, serve 60 days, credit for time served, balance suspended. As to case ending in 1916A, count 1, 12 months probation consecutive to the case ending in 1915A. It would be 12 weeks of anger management, 40 hours of community service, there would be no further contact with Yolanda Dowdy, and stay away from the 953 Washington Street. And just for clarification, he's only doing the anger management once. As to case ending in 1917A, 12 months served, 60 days credit for time served, balance probated. MHET complete an ADET, 12 weeks anger management, no further contact with Gladys Nash. Stay away from 35 Ormond Street. Is the recommendation no alcohol, drugs, or weapons while out on bond? I'm sorry, out on supervision. Thank you.
Yes, Mr. White.
We just accept the plea as negotiated. We would ask that his probation, terminate or go non-reporting at least in the second year, once he's completed all of his requirements. And waive the first 2 months of probation.
And no objection to the non-reporting.
Okay. Mr. Bateman, it's my understanding that in case 26 CR 001915A, you wish to plead guilty to criminal trespass and damage to property and disorderly conduct. In case 26 CR 001916A, you wish to plead guilty to simple battery. And in case 26 CR 001917A, you wish to plead guilty to terroristic threats and acts. Is that correct? You have to speak up for me, sir.
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Not at all.
You've been represented by counsel. Are you satisfied with his representation?
Absolutely.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yeah.
Has anyone forced you or coerced you to plead guilty? Now, I'll accept the plea as negotiated, Mr. Bateman. I will waive the first 2 months of your probation fees to help you get on your feet. If you successfully complete the terms of the probation within the first year, meaning that you get everything done you're supposed to do and that you continue to report to probation as you're supposed to, the second year I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Your Honor.
All right, next we got 11 and 12, Mr. Brown.
And let me go ahead and Ms. McLeod, good morning.
Good morning, Your Honor.
Do you have announcements for the court on your cases?
Yes, Your Honor. Miss Mitchell is currently at ACDC, and I'll be waiving arraignment on her behalf, and I would like her case to be placed on the earliest available trial calendar, Your Honor. With respect to Mr.
What? Just one moment. Let me deal with Ms. Mitchell first. That's position number 48. Penny Mitchell. Ms. Mitchell's there at ACDC this morning. Ms. Mitchell, your case is going to be returned to the division judge, and you'll get notification of your next hearing date, ma'am.
Okay,
Good
thank
luck
you.
to you. Yes, ma'am.
Thank
Okay,
you.
so that was position 48, which is
That is correct, Your Honor.
Okay, the next announcement, Ms. McLeod.
Mr. Snulligan is going to be a negotiated plea, Your Honor.
Okay, that's positions 56 and 57.
That is correct, Your Honor.
Okay. And I'm not sure if you've been assigned to these other cases, Ms. McLeod, but I do have some other cases that require a conflict attorney. Let's see, Ms. Champion or Ms. Grace, can you tell me if position 5, Titus Blaylock has been assigned to conflict?
Mr. Blaylock is my client.
Oh, that's your client already,
believe
Ms. McLeod?
Yes.
Okay,
Your
that's position 5.
Yes, that's Mr. McLeod's case, Your Honor.
Okay, and what about position 54 and 55, Michael Smith?
Mr. Smith is also my client.
Okay, well, they are both on the calendar this morning. And so I'll take announcements. I know, do you need to speak with either of those
I need to
individuals?
speak with both of them, Your Honor.
Okay, so courtroom 2, when it's possible, Ms. McLeod needs to speak with position 5, Mr. Blaylock, and positions 54 and 55, Mr. Smith.
Yes, Your Honor.
Okay. So we'll have you speak with them as soon as they're made available. Who do we
Yes.
have? Thank you. Who do we have next here?
11 and 12, Mr. Brown.
Okay. And this is also a negotiated plea.
Judge, this is actually a non-negotiable.
Okay, and what's not negotiated about it?
Because we're just asking for time served. He's been in jail 89 days on these charges. So we were just asking to not put him on probation, to do the fine, the theft course, alcohol, drug evaluation.
Okay. Yes, Ms. Evans Battle. Oh, let me address him first. Mr. Brown, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can place your hand down. Thank you. Ms. Hutcherson, may I get the history, please?
Yes, give me one moment, please. He has a total of 37 cycles. A conviction from the last conviction I'm showing is from 2005, which is for armed robbery, aggravated assault, possession of a firearm by a convicted felon. And he received a 20-year confinement sentence for that case. And prior to that, 2003 theft by taking and theft by shoplifting in 2003 as well. And nothing further to add. Everything else is in the 90s.
Thank you. Yes, Ms. Evans Battle.
I'm sorry, I've got okay, it's Demario, correct?
Stephen.
Stephen.
Oh, Stephen.
Judge,
Okay, isn't the time calculated as I think it appears that it is supposed to be a time served plea for the 89 days?
Yeah,
Yes.
he's disputing the rest of it. He wants it to be balance suspended.
Because he's been in so long on these charges. He's 66 years old, unemployed. He's recently struck by a car, had his leg broken in 5 places. He doesn't get around well, so we're just asking for this to be time served.
Okay. All right then. Let me look this one up then. I think that the issue is the ADET. They would want him to do that. Okay, this was a transferred case. It looks like. Okay, so this happened back in May of 2025. The officers responded to shoplifting at Walmart at 6149 Old National Highway. The witness indicated that he had placed multiple clothing items in a Walmart bag, attempted to pass all points of sale for the unpaid merchandise. He was stopped near the front entrance. He had stolen merchandise in the Walmart bags. It totaled $163.94 of merchandise. They asked for his name. He gave it as Ronald Keith Brown. Of course, that was a false name. And later was determined that his true identity was Stephen Eric Brown. He was being placed under arrest. There was a search incident to arrest he was found in possession of cocaine and drug-related objects. And he gave the false name, which was the other charge, and the case was transferred down. I take it they dismissed the possession of cocaine charge. So again, our recommendation would be for him to at least complete the alcohol drug evaluation and treatment portion of the recommendations. Stay away from the Walmart at the 6149 Old National Highway in South Fulton. And because of the ADT, it's the state's position that he would need to be on probation in order to accomplish that. Thank you, Your Honor.
Anything further, Mr. White?
Because again, I just reiterate that he's already been in jail 89 days on past charges. His physical limitations, his age, just as that you consider it as straight time served.
He has a place to go once he's released?
Does.
All right. If nothing further, Mr. Brown, it's my understanding that in case 25 CR 004812E, you wish to plead guilty to possession and use of drug-related objects, theft by shoplifting, and giving false information to law enforcement. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your plea, Mr. Brown. The court sentence will be 12 months to serve 89 days, credit for time served 89 days, balance suspended. You'll have to stay away from that Walmart on Old National Highway. Good luck to you, sir.
Thank you very much, sir.
Thank you, Your Honor.
You're welcome.
Yes, the failure to appear also.
Okay.
Is he entering a plea to that?
I mean,
He didn't accept our plea offer, so.
Usually those are dismissed upon arrest anyway. Just
Whatever paperwork you need to get me, Mr. White, to dispose of that case, the court will be willing to sign.
okay, would it just a normal, like we do for the DV bench warrant?
If that's satisfactory,
Okay. Yes, I'll do one of those two, Judge.
okay. Who do we have next?
14, Mr. Burton.
Also a negotiated plea.
It is, Judge.
Good morning. Good morning, Mr. Burton. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, Mr. Burton. Yes, Ms. Evans Battle.
Yes, as to count 1, 12 months served, 22 days credit for time served, balance suspended. Ask that he stay away from the McDonald's at 526 Ponce de Leon. As to case ending in 20676B, count 1, 12 months served, 30 days credit for time served, balance probated, complete. Stay away from the Barnes and Noble and all Georgia Tech properties, a fine in the amount of $500. As count 2, 12 months served, 30 days credit for time served, balance suspended. Stay away from Georgia Tech properties. We do ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you, Judge.
Yes, Mr. White.
Judge, we stipulate, we would ask that you convert the $500 fine to an additional up to 50 hours of community service and waive the first 2 months of probation fees and ask that his probation terminate once he completes his community service.
And does he require a social worker visit to assist with housing?
I'm not sure, Judge. We didn't cover that yesterday, but I'll ask him, and we do have a social worker in the courtroom, so.
Okay. Mr. Burton, it's my understanding that in case 19 CR 001781B, you wish to plead guilty to criminal trespass. And in case 26 CR 002076B, you wish to plead guilty to theft by shoplifting and criminal trespass. Is that correct? Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Burton. I will convert the fine to 50 hours of community service. I will waive the first 2 months of probation fees to help you get on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Judge.
All right, then we got 24, Mr. Clemens.
Also a negotiated plea.
Who is this? Yes, Judge.
Yes, good morning, Mr. Clements. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down, Mr. Clements. Yes, Ms. Evans Battle.
Yes, as to count 1, 12 months served, 34 days, credit for time served, balance probated, complete an anti-theft course, 20 hours of community service. We're asking for restitution in the amount of $127.39 to Letitia Frazier. We ask that he have no further contact with Letitia Frazier, stay away from the 2905 Crest Ridge Drive, East Point location. As to count 2, 12 months served, 34 days, credit for time served, balance probated, complete the anti-theft course, 20 additional hours of community service, restitution in the amount of $200. No further contact with Letitia Frazier. Stay away from the 2905 Crest Ridge Drive, East Point, Georgia location that he stipulated to identity, venue, and a factual basis for the plea. Thank you.
Sorry.
Stipulated, Judge, for the purpose of the plea, we would just ask again to waive the first 2 months of probation fees and ask that his probation terminate once he completes all of his requirements.
Okay. Mr. Clements, it's my understanding that in case 26 CR 001893J, you wish to plead guilty to theft by taking and theft by deception. Is that correct?
Sure.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation? Speak up a bit for me, Mr. Clements.
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right? Say it again for me.
Sure.
Has anyone forced or coerced you to plead guilty? No. I'll accept the plea as negotiated, Mr. Clements. I will waive the first 2 months of probation fees to help you get on your feet. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Your Honor.
All right, next we got 30 through 33, Mr. English. Correct.
Have you had the opportunity to speak with Mr. English?
Yes, Judge, I spoke with him this morning, and this is going to be negotiated.
Okay.
What's that? What'd you say?
We got
Ready to proceed, Mr. White?
Judge.
Good morning, Mr. English. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down. Yes, Ms. Evans Battle.
Yes, Your Honor. As to the first case, it will be 12 months probation, stay away from Skinnies at 897 Virginia Avenue in Hateville, complete 20 hours of community service. And that will run concurrent with the case ending in 7634E, in which the recommendation in that case as to count one is 12 months, serve 30 days, credit for time served, balance, probated, complete, pay a fine in the amount of $500 and stay away from Skinnies at the 897 Virginia Avenue in Hateville. As to count two, 12 months probation, concurrent with count one, which would be to stay away from the location and complete 20 hours of community service. As to the FTA, state would move to null pros that at this time, and we would ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you.
White.
Judge, we do stipulate for the purpose of the plea, same request we'd ask that the $500 fine be converted to 50 hours of community service. And then his probation terminate or go to non-reporting status once he completes his 90 hours of community service. I assume that's 90 hours, or is the 20 hours just once, or is that twice?
I think it would be the 40 hours plus the 50, 90 hours.
We want worst case, Judge, so yes, we just ask that non-reporting or termination once he completes the 90 hours.
Mr. English, it's my understanding that in case 23 CR 005429E, you wish to plead guilty to theft by taking, and in case 24 CR 007634E, you wish to plead guilty to 2 counts of theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning? You've been you need to speak with him, Mr. White?
I don't believe so. He was just raising his hand.
Oh, okay. I didn't know if you had a question. You've been represented by Mr. White there. Are you happy with what he's done for you?
Yes.
You have a right to a trial by jury on these charges. And by pleading guilty to them, you're giving up that right. Do you understand that?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated, Mr. English. I will convert the $500 fine to 50 hours of additional community service. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you. Number 2526, Mr. Derek Coleman.
Good morning, Ms. Rosenhusen.
Good morning.
And Mr. Coleman, this is going to be a negotiated plea.
It is, Your Honor.
Thank you. Good morning, Mr. Coleman. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, thank you. You can place your hand down. Yes, Ms. Evans Battle.
Yes, as to count one, 12 months probation, credit for whatever time he's already served. Family Violence Intervention Program, complete 30 hours of community service. No further contact with Stephanie Cherry. Stay away from the 3272 Dodson Drive connector in East Point. As to count two, it would merge into count one. And then it's to the FTA. The state would move to null pros that case for the purpose of the plea. We ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you.
Yes, Ms. Rosenhuber.
Yes, Your Honor, we will so stipulate, and we're just asking the court to accept the negotiated resolution and to allow Mr. Coleman's probation to go non-reporting after he completes that family violence intervention program. He has also served 9 days in custody, Your Honor.
Okay. Mr. Coleman, it's my understanding that in case 25 CR 005011D, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Coleman. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you.
You're welcome.
With 27, 28, Mr. Dismukes.
Also a negotiated plea.
That's correct, Your Honor.
And what number is that again?
27 and 28. Good morning, Mr. Dismukes. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, thank you, sir. You can place your hand down. Yes, Ms. Evans-Battle.
Yes, Judge. As to count one, 12 months probation, credit for time served, complete an ADET. As to count two, 12 months, pay a fine in the amount of $135. As to count three, 12 months probation, credit for time served, complete the anti-theft course, 30 hours of community service, no further contact with Misty McLean, stipulate to identity, venue, and a factual basis for the plea. And as to the FTA, the state would move to null pros that case. Thank you.
Ms. Rosenhuber.
Yes, Your Honor, we will so stipulate. Mr. Dismukes has been in custody for the past 10 days, so we're asking that he receives credit for those 10 days. And Your Honor, we're asking the court to accept the negotiated resolution and to allow his probation sentence to go non-reporting after he completes those terms.
Does he require the assistance of a social worker for housing?
He advised me that he does have somewhere to reside, Judge, but he was one of the individuals I spoke with over the phone this morning. So I'm happy to let my office know to put him in touch with someone in our office, just in case.
Mr. White, if it's all right with you, Ms. Rosenhuber, Mr. White, can you ask him if he needs some assistance with housing?
Absolutely. Yeah. Okay. He indicates he does, Judge, and again, we have the social worker who shall speak with him as soon as he's done with the plea.
Okay, thank you. Mr. Dismukes, it's my understanding that in case 23 CR 004173J, you wish to plead guilty to possession and use of drug-related objects, pedestrian soliciting a roadway, and theft of lost or mislaid property. Is that correct? You have to speak up a bit for me, sir. Still can't hear you. You might have to get closer to that microphone.
Yes.
Okay, there you go. Thank you, sir. Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right? Was that a yes?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay. For I'll accept your pleas as negotiated for the possession and use of drug-related objects. For the possession and pedestrian in a roadway, I'm gonna have that be a time served sentence. And I will accept the theft of lawful mislaid property negotiated resolution. I'm gonna waive your probation fees while you're on probation to help you get on your feet. We'll have a social worker visit with you to assist with housing. When you complete the terms of the probation, I will have it terminate. Okay, so the sooner you get it done, the sooner you're not gonna be on probation, okay, Mr. Dismukes?
Yes, sir.
All right, good luck to you, sir.
Thank you, Judge.
All right, let's got 29, Mr. Dixon. All right.
What are we doing with Mr. Dixon this morning?
This is also going to be a plea, Judge, negotiated.
Okay, thank you.
Mhm.
Good morning. Oh. There you go. Can you hear me okay, Mr. Dixon?
Yes, sir.
All right, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. You can waive sounding of that first charge, Ms. Evans-Battle.
Yes, Judge. As count one, it would be 12 months served, 60 days, credit for time served, balance probated, complete the Operation 21 law and decision-making course, and 40 hours of community service. As to count two, 12 months served, 60 days, credit for time served, balance suspended. Stay away from Roswell Beverage at 10498 Alpharetta Highway in Roswell. We ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you.
Ms. Rosenhoover?
Thank you, Judge. We do so stipulate. Mr. Dixon has been in custody now for the past 18 days. He also did advise me that this situation may have resulted from a medical condition he has. I believe he does have some kind of physical impairment, though we didn't get into the details of that. Your Honor, he does want to move forward with this plea and take responsibility. However, we would ask that the court accept the negotiated resolution, give him credit for that 18 days he's already done. I did explain to Mr. Dixon that the court may not be able to assure him of an exact release date, but after calculating it, I gave him a potential release date. And additionally, Judge, we would just ask that the court allow probation to terminate after completion of the terms. Thank you.
And does Mr. Dixon have is he in need of a social worker visit to assist with housing?
He was another individual I spoke with this morning. I apologize, Judge.
He's already spoken with a couple of social workers, Judge. So,
Okay. I guess really my question is, does he, aside from us assisting with us, a social worker, does he have a place to live, or is he gonna need some time to get himself on his feet?
yeah, he's good.
Okay, all right. If nothing further, Mr. Dixon, it's my understanding that in case 26 CR 001897F, you wish to plead guilty to criminal trespass and one other misdemeanor offense, is that correct?
Yes, sir. Can I say something real quick, though?
You have a right to remain silent. Anything you say can be used against you. Go ahead and ask, if it's all right with you, Ms. Rosenhoover, can you go ahead and ask Mr. White his questions?
Of course, Judge.
Judge, he just wants to know when he's getting out of jail. And I'm sorry, I didn't hear the recommendation or know what amount of time he's done, so I can't answer that for him.
Okay. He's done, it's my understanding that the sentence is a 60-day sentence. He's already done 18 days.
And Judge, just for the purpose, I know he wants to count the time that he's already served. He has a 60 cycle history, which is why we're asking for the time that we are normal, just so that the court is aware.
Thank you.
Well, I got to say something. It's not like, man, I just want to know when to get it out.
Your Honor, he's just concerned that, I've explained to him he has 12 days to 2 for 1. And he just wants you to know that, he's concerned that he won't be released as well.
Okay. Mr. Dixon, I don't have any control over when the jail there releases you, nor do I have any control over, they normally give 2 for 1. I would imagine that they will do that for you as well. I cannot guarantee that to you because that's up to the jail. But if they do what they normally do, they will give you 2 for 1. Okay?
Yes, sir. Sound pretty good, yeah.
All right, very good. I'm Mr. Dixon. Are you under the influence of any drugs or alcohol this morning?
No, I'm sober, I don't know what.
Okay, you've been represented by counsel. Are you satisfied with her representation?
Yeah, oh, yes, I'm satisfied. And she did a very good job.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Oh, no, sir.
Okay, I will accept the plea as negotiated, Mr. Dixon. I'm going to waive your probation fees for you while you're on probation, and when you complete the terms of the probation, I'll have it terminate. Good luck to you, sir.
I'm in the plan, yes, sir.
Thank you.
Good luck right now.
No worries.
All right, yes, sir.
All right, then we got 56, 57, Mr. Snelligan.
And Mr. Snelligan is going to be a negotiated plea, Ms. McLeod.
Yes, Your Honor.
Okay.
I was trying to speak.
Like relocate and they trying to do 12 months. That's about the same. I'm just saying. What else?
Okay, you ready for me, Mr. Snelligan? Good morning. I'm Judge Eric Mara. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, sir. Ms. Evans Battle?
Yes, sir. As to the first case, is 12 months probation, credit for time served, balance probated, complete 40 hours of community service, stay away from the Georgian Terrace Hotel located at 659 Peachtree Street Northeast. As to the second case ending in 1979B, 12 months probation, credit for time served, balance probated, complete 40 hours of community service, stay away from the Georgian Terrace Hotel at 659 Peachtree Street Northeast, and it's to run concurrent with the other case. Ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you.
Yes, Ms. McLeod.
Your Honor, that is our understanding of the terms of the plea. And I would ask the court if my client's probation fees could be waived for the first 2 months to allow him to get the community service done, Your Honor. And that once he's completed, if his probation could go non-reporting.
Okay. Mr. Stoligan, it's my understanding that in case 26 CR 001365B, you wish to plead guilty to criminal trespass, and in case 26 CR 001979B, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yeah.
Has anyone forced or coerced you to plead guilty?
Um,
I'll accept the plea as negotiated. When I will waive the first 2 months of your probation fees to help you get on your feet, and when you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
You're welcome.
All right, this got 54-55, Mr. Smith.
What are we doing with Mr. Smith this morning?
Your Honor, Mr. Smith is going to be a non-negotiated plea.
Okay, and what's not negotiated about it?
Almost everything, Your Honor. But the most important thing is on the first case is contact with the alleged victim. The state wants no further contact, and my client wishes no further violent contact with Quintoria Wynn.
Okay. I see that Ms. Wynn is on the line with us. Let me find out. Good morning, Ms. Wynn. I'll be with you in just a moment.
Okay.
So let me first get the history, Ms. Hutcherson, please. While she's doing that, let me go ahead and address. Good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Yeah. Thank you, sir. You can place your hand down. Ms. Hutcherson, are you with me?
Your Honor, Ms. Hutchinson stepped away for a second. She says she'll be back shortly.
Okay. Thank you, Ms. Champion. Let me go ahead and hear the facts, Ms. Evans Battle, please. Ms. Evans Battle, are you with me? Okay.
Okay. So yes, this incident occurred, it looks like June the 1st of 2025. And they were called to the 2545 Old No Drive Northwest. And it was at about 1 o'clock in the morning, in which Miss Wynn indicated that he had asked her for $50. She denied his request. Then he came around to the driver's seat and snatched her phone, grabbed her head, and slammed it against the gear shift, which resulted in her chipping her front tooth. He then demanded that she get out of the vehicle. And once she got out of the car, then he began grabbing her 5-year-old from the back seat and her 1-year-old. I'm sorry, Miss Wynn got out of the car and began getting the children, the 5-year-old and 1-year-old, out of the back seat. And then Mr. Smith snatched the 1-year-old child out of Miss Wynn's hands. At that point, she began to run down the street. He then began to drive down the street following her. He got out of the vehicle with the 1-year-old and told her to grab the child. When she attempted to grab her daughter, he grabbed her by the hair and drug her down on the ground. He then grabbed her and threw her into the passenger seat, and he still had her phone in her hand. He began going through the phone, asking her, "Who is this guy you're texting?" And when she was not responding, he took the phone and swung it towards her face. The phone ended up hitting her in the lip and busted her lip. He got out of the vehicle and told her, "If you don't be back when I call you, if you don't be back when I call you to come and get me, I'm going to kill you and your children." He then, when the officers, let's see, she asked, then that was the officer just talking about he ran her information. And his information, he did indicate that he saw that she had the chipped tooth, the busted lip, a scratch on her chin, swelling above her chin. She indicated that she was okay. She said that they had been living together since February. However, she had left the apartment about a month ago. And I want to see if there was anything else. That's what I have regarding the facts of the case so far. There was another incident that occurred, which is the May the 4th, 25th incident, in which she indicated that they were in a verbal dispute and that he began hitting her multiple times in the head, knocking her down on the floor while she was holding their 1-year-old. She got up and tried to get a hold of the 1-year-old, but she was falling to the ground. He pointed a gun at her head, stating, pick up my shit up off the floor. She stated that her 16-year-old son had come from another room and said, and told him he didn't care. I don't care if you call the police, I'm going to beat your ass. That's when he walked up, took the keys, but he didn't take the car at the time. She provided a description of the weapon to the officer and told him what had happened. She also indicated that on that same Sunday that he had followed her to the car and opened the driver's side window and started choking her with both hands, pushed her towards the middle part of the car, that he drug her out of the car, and when that he drug her out of their car, that she attempted to run to a room during some point in time, and he choked her again and tried to strike her. She stated she then started hitting the wall because she was losing her breath and the kids had to intervene in the situation. She attempted to run to the kids' room. He followed her as well. And so those are the facts regarding to both of the cases.
Oh,
And
Ms. Evans-Battle, I don't have any. I have position 54, which has 2 battery family violence on the same date. That second incident that you're talking about there, I don't see anything on the calendar in regards to that.
Okay, that was just the information that was contained in the warrant. And as I was reading the warrant, I saw that there was a second page, and he may not have been charged because I'm not sure who drafted the accusations. I was going to check to see if this was possibly a transfer. I don't know why it wasn't even transferred. It's really a case that probably should have been transferred to the felony division.
Can I speak?
No, not right now, Ms. I'm going to allow you to speak, but give me a moment.
Yes, but I'm not sure of that. So the court heard the facts of the June 1st case and some of the history behind this. And I know that she's on here and it may have been a period of time. I don't believe there was anyone available to give you his history if the court would like me to.
I'll see if Ms. Hutcherson is back with us.
Okay.
Yes, Judge, I'm back.
Okay. Do you have Mr. Smith's position 54 and 55 as history?
Yes, he has a total of 26 cycles. He has a June of 2025 conviction for 3 counts of aggravated assault, a 2022 burglary conviction, a 2021 driving while license suspended or revoked conviction, 2019 theft by taking and willful obstruction of a law enforcement officer conviction, 2017 burglary, 2015 theft by taking and battery family violence, 2014 fleeing or attempting to elude, 2008 aggravated assault, simple battery, possession of a firearm by a convicted felon, and then a 2008 willful obstruction of a law enforcement officer, theft by receiving stolen property, marijuana.
Okay, let me see.
And 2006, theft by receiving stolen property and theft by shoplifting convictions. And nothing further to add. I believe he has an open case and felony, but I'll have to check in Odyssey for that case. It was a case from October of 2025 for battery, family violence, and aggravated assault. And there's no disposition listed. So I believe that's an open case.
Okay. Thank you. Ms. McLeod, do you have, as far as the DUI goes, are you going to, is that going to be negotiated or is that also non-negotiated?
It's also non-negotiated, Your Honor.
Okay, I'll be with that case first. Let me speak with Ms. Nguyen. Ms. Nguyen, if you would like to address the court, now is your opportunity to do so. I'll need for you to unmute yourself. Yes,
Hey,
ma'am.
good morning, Judge. How you doing?
I'm doing well, ma'am. If you can raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, if you could stand steady for me while you're speaking to me, I'd appreciate it, okay?
Yeah, I'm sorry, I'm at work. I'm sorry.
Okay, so find a steady place to address the court, and what would you like to tell the court?
I as I explained to the lady the other day, I would like for the charges to be dismissed if they can be dismissed. If they cannot be dismissed, I would prefer him to take an anger management class. We are still together. We have a child together, and I explained it to the lady that called my phone the other day. And that's all. That's really it.
All right, I appreciate you being here, ma'am.
Okay.
Yes, Ms. McLeod.
Yes, Your Honor, my client tells me that he's been locked up for more than 5 months on these charges. So he is concerned about the length of time. He was hoping that he would get time served for this, the battery charge, and also for the DUI, because he explained to me that he spent several months in Fulton County, then he went to another county, and then he's been back in Fulton County. He explained that the whole incident was not as the state has alleged, and I do recall that when Ms. Wynn had come on the when he initially appeared, she had stated the same thing, that there were a number of inaccuracies in the warrant and police report as to what happened, and that what the state was alleging did not in fact happen that way. Also, this is the first time I am hearing the allegations about a second incident, Your Honor, that was never raised when he initially appeared.
And I'm sorry, that second incident is the felony case that they have. The May the 25th case is that's the one that's open under the felony division. So
okay.
Well, they have a
sad.
child together, and that's a big issue. He wants to have contact, and so does she, and they are sharing a child.
Okay, well, it sounds like he doesn't want to plead guilty if he's not going to accept the responsibility of what he is alleged to have done. So I don't know if I'm amenable to accepting any type of plea agreement if he's not going to accept responsibility for what's alleged against him.
No, Your Honor, he is willing to accept responsibility. He states that to me. He was just hoping that he would be able to get there would be less things for him to do, because this is quite a few things that he would have to do. And the biggest
this is also
contact.
It's also statutory. So there's nothing I can do about the FVIP. There's nothing I can do about any of the things that have to do with the DUI. So he's going to have to do that based on Based on what I've heard this morning, I'm very concerned about this this young man and his family. I don't even know if I would accept the recommendation at this point, the way that the state has it, because with the children that are involved, I believe that some parenting classes are necessary. I'm going to give him the opportunity to get all of these things done. So I'm going to have the charges run consecutive and not concurrent. So the court is not going to accept the state's recommendation. The court is going to add some conditions and also make it a consecutive sentence. So if you need time to speak with him regarding what the court plans to do, I'm happy to give you that opportunity. But based on his history, based on the pending charges, based on what I've heard here this morning, that's going to be the court sentence.
Your Honor, what about the issue of contact?
Oh, there will be no contact, at least not until he begins the family violence. He can have third-party transfer of that of any minor children that he's taking care of. But until he gets some help through this family violence intervention program, there will be no contact.
I will have to speak with him about this, Your Honor.
Okay, I'll give you that opportunity.
Thank you,
And
Your Honor.
and given that I don't know if it's a time served plea with this 90 days, but if you need for me to reset this till next week, I'm happy to do that.
I can speak with him, Your Honor.
Okay,
I
all
only
right.
have like SAP on my calendar today, so.
Okay, all right. So we will, I'll give you the opportunity to speak again with Mr. Smith there.
Thank you, Your Honor.
You're welcome.
Well,
Who do we have next?
number 34, Mr. Floyd.
Briefly, Judge, just like Ms. Evans Battle, I don't know, I sent you a message, if you could relay an offer to me by message. I know you did by email, but I don't have access to that right now.
Okay, so this is position 34, Mr. Floyd. And that'll be a negotiated plea?
That is correct, Your Honor.
Yes, good morning, Mr. Floyd. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Say it again for me. One more time. Okay. We're having a hard time hearing you for some reason, Mr. Floyd.
Yes, sir.
Okay, very good. Thank you. You can place your hand down. Yes, Ms. Evans Battle.
Yes, Judge. As for Mr. Floyd, it's 12 months, served 90 days, credit for time served, balance suspended, stay away from the MARTA. He has a permanent suspension and he needs to, we would ask that he comply with that suspension. Note that he stipulate to identity, venue, and a factual basis for the plea.
Ms. Rosenhoven.
Yes, Your Honor. We will so stipulate Mr. Floyd has been in custody for 18 days, and he does accept responsibility. As this is a balance suspended sentence, I have no specific requests other than that the court accept the recommendation.
Yes, Mr. Floyd, it's my understanding that in case 26 CR 0018828, you wish to plead guilty to criminal trespass. Is that correct? Say it again for me. Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with her representation? You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right? Say it again for me. Still can't hear you. Still can't hear you. You got to speak up for me. Has anyone forced or coerced you to plead guilty? I'll accept the plea as negotiated, Mr. Floyd. Good luck to you, sir.
All right, number 36 through 38, Mr. Henson.
And Your Honor, this will not be a negotiated plea. I do believe that Mr. Hinson would just like some clarity. I tried to explain to him a few different aspects of the case. I think there's some confusion since he did recently have a probation revocation before Judge Edline. He is also on her calendar on the 13th, but he asked to be brought to court.
Okay, so he's on Judge Edline's calendar for different charges.
For these three cases, all three are showing in Odyssey that they've already been added to a jail status calendar. Perhaps they were still on SAP just in case he wanted to resolve. We didn't quite get there yesterday, but
Okay, so I'm happy to, if he does not want to accept the plea, I guess that it will have to go back to Judge Edline and she can speak with him in her court. Is there something specific that he needs from the court this morning?
Your Honor, I advised him that it sounded like he wanted to waive arraignment and plead not guilty, and he advised me that he wanted to still come to court. So I since I didn't have permission to waive his presence, and I didn't want to. Okay.
All right, so good morning, Mr. Henson. I'm Judge Eric Morrow. This is the state all-purpose calendar. You have a right to remain silent. Anything you say can be used against you. You have the right to have an attorney present at these proceedings. We're providing you with the assistance of a public defender this morning. It's my understanding that these cases are already with the division judge, Judge Edline. And do you wish to plead guilty or not guilty to these charges today? You have been charged in case 24 CR 007164D with criminal trespass and willful obstruction of law enforcement officers. And you've been charged in case 26 CR 002051D with willful obstruction of law enforcement officers and simple assault. How would you like to plead to those charges?
Can I ask what the plea is? Like, what's the deal?
Okay, of course. So you need to speak with him again, Ms. Rosenhoover, to let him know what the offer from the state is.
Judge, if he wants me to tell him again, I just do want to be clear. I did convey this yesterday. I'm happy to speak with him, though, to convey the offer again. Absolutely.
And just so the court is aware, this has been the offer every time he's come to court. I believe he's been on this calendar about 3 times. So I know that he's spoken with other attorneys who have relayed the same plea offer. It hasn't changed.
Okay, so
there's some other issues going on that.
Okay, so why don't we do this, just so he knows from you, Ms. Evans Battle, as well. Go ahead and put it on the record for me what the offer for the cases will be.
Okay, it's for count 1. It's 12 months, serve 120 days, credit for time served. And I know it's been adjusted, the time consistent with how long he's been incarcerated. Balance probated, complete an MHET, stay away from the target. MHET being a mental health evaluation and treatment. Stay away from the target. Location at 6000 North Point Parkway in Alpharetta. Complete 40 hours of community service. Count 2, which is willful obstruction of law enforcement officer, is 12 months probation to run together with count 1 and complete, pay a fine in the amount of $300. The additional open case is for willful obstruction. It is also for 12 months probation to run concurrent, and it is for a fine in the amount of $300. As to count 2, which is a simple assault, it's 12 months probation to run concurrent with the case ending in 7164D. It is for him to complete 12 weeks of anger management and 60 hours of community service. No further violent contact with law enforcement officers. And we want him to stipulate to identity, venue, and the facts of the case. Thank you.
So that's what the state is offering, Mr. Henson. Do you need to speak with Ms. Rosenhoover about what you'd like to do this morning?
Uh,
Say it again.
Yeah.
I'm sorry, sir. I still don't understand you.
Wanna accept the plea.
You said you want to accept the plea.
Okay, Judge, I can speak with him and fill out the
Okay.
paperwork and we can come back.
Okay, so we'll have Ms. Rosenhoover speak with you, Mr. Henson. We'll be back with you. Thank you, sir.
All right, going back to Mr. Smith.
So we're 54, 55, I believe. Mr. Smith. Yes, Ms. McLeod.
Your Honor, I have spoken with my client and he will be accepting the negotiated plea according to the terms laid out by the court.
Okay. Anything further, Ms. Evans Battle?
No, Your Honor, thank you.
Anything further, Ms. McLeod?
Nothing further, Your Honor.
All right. If not, Mr. Smith, it's my understanding that in case 25 CR 006160L, you wish to plead guilty to battery family violence. And in case 25 CR 006182L, you wish to plead guilty to driving under the influence of alcohol. Is that correct? Speak up for me, sir.
That's correct.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept your plea, Mr. Smith. I will accept the state's recommendation as to position 54, with the exception of I'm adding 10 parenting classes to that recommendation. I will also accept the recommendation of the state as for the driving under the influence of alcohol. I will have that charge run consecutive to position number 54. If you complete the terms of the probation within the first year, I will have the second year go non-reporting. So if you report as you're supposed to, if you get everything done that you're supposed to, then I will have the second year be non-reporting. At this time, until you begin the Family Violence Intervention Program, you understand, and Ms. Wynn is on the line, that you're to have no further contact. Okay, if you start that program and petition the court to have contact once you've started the class, then that can be a modification possibly that's made down the line. But at this point in time, just know that if you violate that term, then you'll be violating your probation and you might be right back where you are here today. I believe that covers everything. Good luck to you, sir. You as well, Ms. Wynn. I will allow for third-party transfer of any minor children that you have with Ms. Wynn. So that I'm not going to keep you from any children that you have. But you'll have to have third-party transfer of those minor children for your visitation.
And-
All right.
And
Good luck to you.
Judge, can you clarify for us on the Family Violence Intervention Program? I would hate for him to register for the program and take the first class and come back and ask for modification. So could you give some additional guidelines or?
Yeah, that is. I will be happy to, Ms. Evans Battle. That's a 6-month class, Mr. Smith. So you need to get into the class, start taking the class, and once you are, a good ways into the class, you can have someone, or you can come back and ask for a modification. Don't, it will be a waste of your time to take one class and then think that you're going to get it modified possibly. But you will have that option down the road.
Yes, sir.
Thank you, Your
All
Honor.
right.
Thank you.
Anything further?
Your Honor, I have spoken with Mr. Smith, and he is going to take the class. We talked about all of that because he would really at some point like to have contact, and he does acknowledge that, you know, he was not at his best on that particular occasion, Your Honor, and he is remorseful about everything that happened because we spoke about it.
Thank you, Ms. McLeod.
You're welcome.
Good luck to you both.
All right, next we got position number 5, Mr. Blaylock.
What are we doing with Mr. Blaylock this morning, Ms. McLeod?
With Mr. Blaylock, Your Honor, we will be doing a request for a modification of his bond.
And what is the current bond?
The current bond is 20,300, I believe. Good bond.
Ms. Hutcherson, may I get his history, please?
Yes. A total of 27 cycles. I'm showing an arrest from 2021 for aggravated stalking, but there's no disposition, so the case could possibly be open. One FTA from 2019, a battery family violence conviction from May of 2022, a driving without a valid license conviction in 2014, a theft by receiving stolen property conviction in 2009, forgery in the first degree conviction, 2007, battery, family violence conviction, 2005, and then a battery, family violence conviction in 2001, a battery and simple battery conviction in 99, and nothing further to add.
Yes, Ms. Evans Battle.
Yes, Judge, this case appears to I just want the court to be aware that the cases that she named, there's a case in the 2017 case, there's the same victim. On the 2019 case, it's the same victim. Those are the two battery family violence cases. As to the 21 case aggravated assault stalking, it's the same victim. As to the case in 2022, battery family violence, wow, that's a different victim. To the 24 battery family violence case, it's the same victim. And there was one that was null processed in DeKalb, it was the same victim. This case was the case from October of 2025, he came to the victim's home to see his 12-year-old daughter. The victim stood on the porch to watch her, and he walked up to her and said that he should slap the hell out of her right then. I don't know, there appears to be an additional case that from March the 16th, that may not be on the calendar. So I'm looking at notes, but I actually need to probably pull the warrant. Because mhm.
1601.
Yes, that is basically he was screaming and yelling at her as well. That appears to be what happened on this particular date, on the October date. Apparently there's maybe another, I don't know what this is.
Is it my time to speak?
Yes, because that's basically what I have for the October date. I have another March the 16th date. So that's what I have for this case.
Would you pull up the bond on this case for me, Ms. Evans Battle?
I will.
I'll come back to you when you get that up for me. Yes,
Okay.
Ms. McLeod.
Your Honor, I am asking for a signature bond for my client. I was able to speak with Mr. Blaylock at length about what is going on here. The alleged victim is his wife, but they are estranged. They share a 12-year-old child. He tells me that she has done this before. She can get vindictive because she had called him over to watch his child, to actually watch the child, not just to see the child, to watch the child for him while he was at her house, her current boyfriend, because they are no longer, they are estranged, but they do share the child, and they've been estranged for more than 6 years. The child is 12 years old. He said while he was at her house, her boyfriend came there. The name of the boyfriend is Victoria Whitaker. And my understanding is that he's actually incarcerated at the moment in Fulton County Jail. The boyfriend stabbed my client at the house. My client called the police and he was arrested. He said she got upset and decided that she was going to call the police and have him arrested. So this is a made-up claim that he threatened her. He said he, in fact, did not threaten her, but she was angry with him because he had her boyfriend arrested because the boyfriend had stabbed him, Your Honor. I'm asking for signature bond for my client because, of course, he cannot post a bond. He's not in a position to post bond at all, Your Honor. And based on what he tells me, and even their history, it doesn't say that they have had anything together in quite some time. So I'm asking for signature bond for him so he can get out of jail. He has absolutely no problem having no further contact with her because they don't have contact like that. It's just that they share this 12-year-old, Your Honor. And the allegations that he made, he told her he was going to beat her up or whatever it was, or threatened her, he totally denies that. He said she's just angry with him because he had the boyfriend arrested. Nothing further, Your Honor.
Yes, Ms. Evans Battle.
The bond is a $20,000 good bond, and no contact with Miss Blaylock, and to stay away from the location. And I was trying to see if I argued this particular case, and I know in looking at his history of this victimization of this same person over and over again, I think that was one of the reasons in which Judge Mincy could have found that it was necessary to place the bond in the category that she did.
Miss Evans Battle, are you aware that there's a case pending where he is the victim and the perpetrator in that case, the wife's boyfriend?
Right, that person was not noted in this particular warrant, and I did look because I was trying to figure out how the incident happened in October, and it was the 16th of March. So there appears to be something else done, like another charge. I don't see it, but we have the March the 6th, we have a March the 16th of 2026 issue. And so
What type of?
I don't see a warrant for that, but that's how this case came to be. When the officer responded to the home on the 16th because of an incident, involving where she's, indicated he put a cake cutter to her neck. They found the warrant for the terroristic threats. And so they arrested him on the warrant that was already outstanding, but that other charge has not come through yet. And I can't tell you why, because I don't know.
Miss Evans, she said that he threatened her. She said he put a cake cutter to her neck. These are all based on what she said. It
I
sounds to me they
understand.
have no real evidence that he did any of this. So, in my opinion, it more supports what he's saying, that she's angry with him because he had her boyfriend arrested for stabbing him when he was watching his child at her home.
And I don't know anything about that. Again, the child is present during this incident, so the police apparently talked. I don't know if the police spoke with the child there or not, but still, our position, nothing has changed. You've got at least 6 cases involving the same victim, and those are convictions. So we're not even talking about the other cases. We're talking about the
6 convictions regarding this victim based on what I heard. But in this case, the allegation is that he made terroristic threats, correct? She just said he said something to her. It's not even like he sent a text message this is just she called the police and said he said this. That is why he's sitting on a 20,000 plus bond based on an allegation that he said something after her boyfriend, and her boyfriend stabbed him and is in jail for that reason. Doesn't it give you some kind of pause that he may well be right, that she's just trying to get even with him?
I think the state position is it might give them pause if he hadn't had all these other convictions with the same victim in the past.
Yes,
okay, but we can't litigate this today, so this is just the bond here, and I'll let you all litigate it down the road. What I will do, I'm not going to give him a signature bond, Ms. McLeod, but I will reduce the bond to a $5,000 good bond. No further contact with Ms. Blaylock. Stay away from her residence. Third-party transfer of any minor children for visitation, and no drugs, alcohol, weapons while out on bond.
Thank you, Anna.
Okay.
Mr. Blaylock, the judge has already made his ruling, and I'm suggesting to you that you do not speak. Just maintain your right to remain silent.
Okay. If nothing further, good luck to you, Mr. Blaylock.
I do have something further, Your Honor. That case,
okay.
The case that Ms. Evans was looking at in 2024 in March was another alleged allegation of me striking her in the face, of my wife in the face. And I was in McDuffie County at the time.
Okay. Hold on, Mr. Blaylock. You have a right to remain silent. Anything you say can be. I understand that you want to speak, but that might not be to your best interest this morning.
I was just letting you dismiss because it was fabricated, just like this one.
Okay. Well, I've lowered your bond, Mr. Blaylock. Good luck to you, sir.
Thank you, Your Honor.
All right, going back number 36 to 38, Mr. Henson.
Judge, I'm sorry, really briefly on Mr. Henson, I'm working on getting copies of the plea paperwork sent to Mr. White so that Mr. Henson can review them. Is there another position that the deputies are able to take while we just make sure everything's okay?
Yeah. All right, we'll go to position number 41 through 44, Mr. Johnson.
Thank you.
Marion Johnson.
Miss Rosenberg. Actually, Mr. Henson says he can go forward. I explained to him that the judge is going to confirm everything that you discussed, and I think that's satisfactory for him to go forward.
Okay, perfect. Thank you so much.
Okay, so we're back with Mr. Henson, 36 and 37. Mr. Henson, you are still under oath. Let's see. We have already, Ms. Evans Battle, placed the state's recommendation on the record. Anything further from the state?
No, Your Honor.
Okay, Ms. Rosenhuber, anything
Yes.
further?
Just really briefly, Judge, we are asking, of course, that the court accept the negotiated sentence. I do want to make a note that the 26 CR case appears to have been a transfer down from Superior Court. On the jailing screen, the PI number is still listed. I wrote that number down on the sentence or on the plea sheet, but if it would be helpful to put it on the record or to have it indicated in the disposition, I'm happy to read that number out for the court.
Just do that out of an abundance of caution, Ms. Rosenhuber.
Thank you, Judge. That case number is 26 PI 001597. But otherwise, Judge, we would just ask the court to accept the recommendation.
Okay. Nothing further. Mr. Henson, it's my understanding that in case 24 CR 007164D, you wish to plead guilty to criminal trespass and willful obstruction of law enforcement. And in case 26 CR 002051D, you wish to plead guilty to simple assault and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Henson, when you complete the terms of the probation, I'll have it go to a non-reporting status. And it's my understanding that the failure to appear will be non-crossed. Good luck to you, sir.
Thank you, Judge.
At 41 through 44, Mr. Johnson.
Yes, good morning. Is this Mr. Mergler?
Sure.
Yes, good morning. What are we doing with Mr. Johnson this morning?
Mr. Johnson is going to be a not guilty this morning, Your Honor.
Okay, a waiver will be filed. Is that correct?
That's correct.
Mr. Johnson, your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
And can I ask if the for Mr. Johnson, there was another case and I intended to get the clerks to bring. Okay. All right then. Just try that. Oh, I'm just having a day. Thank you, Judge.
Your Honor, if we could confirm that his includes a $2,000 bond is still.
You have Ms. Evans Battle, do you have his bond information?
That's what I have noted, Your Honor. You just want to confirm.
See if Ms. Evans Battle can pull it up.
Okay, you said $2,000? I have a $3,000 bond for the criminal trespass from the 9/1/2025. And let me see for the other case. And he's got on that Affray case, there's a, well, it was pretrial release. I know that's not correct. There was a dormant warrant. bond forfeiture in that case. Hearing coming up.
So it seems like there's been some confusion about this bond. What she's saying about bond.
So for the, as for the criminal trespass was the $3,000 and there was a dormant bench warrant, from his failure to appear on December the 15th of 2025 on the Affray case, which he had been under pretrial release for.
Yeah.
Yeah.
All right. We're gonna start.
Okay. All right, good luck. Good luck to you, sir.
We got 45, 46, Mr. King.
This is a negotiated plea, counsel.
Yes, Your Honor.
Okay, good morning, Mr. King. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Ms. Evans Battle.
Excuse me, Miss Battle, we haven't heard, I couldn't hear anything you stated.
That's because I was on mute.
Shut
It
your mouth.
thank you so much. It's 12 months probation, credit for time served, balance probated, Operation 21 law and decision-making course, complete 30 hours of community service. The state would move to null pros the FTA and ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you.
Yes, Mr. Murgler.
Yes, we do stipulate reverse the plea. I was gonna ask if we could waive his probation fees. He's a young man. He's been trying to get a job. He had some job interviews going on when he got picked up, and he'd like to continue looking for a job. So I'd like to help him get back on his feet when he gets out by waiving some fees.
You have a place to live?
He does.
Okay. Ms. Evans Battle, what were the circumstances around this giving false information?
Just a moment, please, Judge. Thank you.
And can somebody tell me how much time he served?
I believe he's been in at least a week, Your Honor. Okay.
Mm.
I put it on experience since 29.
Thank you.
Judge, I'm showing 11 days from the booking screen. Oh, no, we're on, sorry. You're talking about King, right, Judge?
Yes, Ms. Grace.
If you're ready for me.
Yes, Ms. Evans Battle.
There was a accident or collision that occurred, and Mr. King was the passenger in the vehicle, and he provided the officer with the name of Darius Glenn, and his name is which was not the correct which was not the correct name, and the officer ended up calling his mother and got the correct name on the report for insurance purposes. And he had multiple active warrants out for him, which is why I gave the false information at the time.
Okay. All right. Anything further from anyone? If not, Mr. King, it's my understanding that in case 24 CR 008187F, you wish to plead guilty to giving false information to law enforcement. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. King. I will waive the fees while you're on probation. And when you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, sir.
All right, then, 47, Mr. Lash.
What are we doing with Mr. Lash, counsel?
Your Honor, I believe this is going to be a not guilty unless we are able to make a little headway here with Ms. Evans Battle. Yeah. Sorry, just refreshing my notes real quick. Yes, we're going to do it.
Evans Battle, obstruction is normally a $300 fine. Is there a reason that the state's asking for a $500 fine?
Yes, we would normally, if he has a prior conviction for obstruction, then that's by statute, I believe.
So he has a prior
Conviction
obstruction.
for obstruction.
So Mr. Merber, what are we doing with Mr. Lash?
I believe we're going not guilty. He is not too thrilled with these terms. Your Honor feels that they're quite harsh.
Okay. So if you'll file a waiver, Mr. Lash, your case will be returned to the division judge. You'll get notification of your next hearing date. And so all the terms, I don't understand what terms that he's not satisfied with, given that it's 30 hours of community service and a law and decision. Oh, you're talking about the time in custody.
Yes, sir.
Okay, all right. So your case will be returned to the division judge, Mr. Lash.
Thank you.
Good luck to you, sir.
I see.
Okay.
And then we have 39, Mr. Hooper.
And this is a bond hearing.
That is correct, Judge. Technically a bond reduction hearing, but yes, Judge.
And can you tell me what the current bond is?
Yes, Your Honor. It is currently set at a $3,000 good bond, with the conditions that he has no contact at all with the alleged victim, Miss Angela Williamson, and that he stay away from the incident location and have no firearms, drugs, or alcohol, I believe.
And I said,
Hold on, ma'am, give me a
okay,
moment. Ms. Evans
okay.
Battle, can you pull that bond up and see if it's something that I signed or if another judge signed it?
Yes, Your Honor, I did pull it up. It is currently set as $2,000 on the battery and 1,000 on the disorderly conduct for a $3,000 good bond. Judge Mincy signed the bond in this particular case.
Okay, and go ahead. I'm sorry, Ms. Evans Battle.
No, I didn't know if the court wanted me to receipt.
I do. I want to get the history first, if you don't mind. Ms. Hutcherson, may I get Mr. Hooper's history?
Yes, 31 cycles, 3 out of South Carolina, 28 out of Georgia. A 2021 conviction out of South Carolina for 3 counts of assault and battery in the first degree. A 2018 conviction out of South Carolina for DUI, driving without a valid license and open container. A 2023 conviction, Georgia, willful obstruction of a law enforcement officer. 2022 conviction, Georgia, hit and run, driving while license suspended or revoked. 2020 conviction out of Georgia, possession of meth, willful obstruction, giving false name. 2018 conviction out of Georgia for aggravated assault and criminal damage to property. 2016 conviction out of Georgia, simple battery, 2 counts, criminal trespass. A 2015 conviction for willful obstruction and hit and run. 2014 DUI conviction, FTA 2014, and then a burglary conviction in 2011. And nothing further.
Thank you. Yes, Ms. Evans Battle.
My understanding he has a current probation violation and one from 2025 as well, and one from 2023 as well. He has an FTA from 2020. So in this particular case, the incident occurred at 3166 Desert Drive on March the 22nd of 2026. He arrived at the location. He was intoxicated. He grabbed her cup of tequila from her windowsill and threw it on her. He then began to knock her furniture down and around and about in the location. There was a witness who advised that that person stood between them because he was so aggressive that she feared that he would continue with the violence. And also the person was making sure he wouldn't continue to knock the property of the victim around. The officer went to the location. The officer made observation that her shirt was wet, which would have been consistent with what she had indicated. The officer also saw that things were laying around on the ground. And when the officer arrived, he was not able to be located at that particular time. So our bond recommendation was for the $3,000 surety bond, and we would ask the court to that the bond remains set as it is. There's been no particular changes between the time of that hearing and this hearing, but for the fact that the condition of bond that Judge Mincy set out indicated that he was not to have any contact with the victim. Those bond conditions include that there's not to be any telephone contact. We did listen to jail calls in this particular case, and he reached out to the victim 233 times between March the 31st and today. 193 of those calls, which he made contact with her. There were instances on those calls in which the state would be concerned. They were arguing, bickering over the telephone. There were times that they were just speaking with each other. And there were times that, the state would contend that he is intimidating her because he's continued to call her over and over again. Even after she repeatedly tells him not to call, then he will continue to call her. So this is a case in which we believe that the bond recommendation should stay as it is, and that he should not get a bond reduction at this time. Thank you.
Ms. Williamson, if you would like to address the court, now is your opportunity to do so. I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Were you present at his previous bond hearing?
No, I wasn't, but I did do an affidavit, as far as I just got some news I'm pregnant, so I don't wanna I wanna try to work things out with him and us go to relationship counseling, but I do want him to be present with me. This be my first pregnancy, and I believe he can change. And I do want to drop the charges. I really do need help with this pregnancy. I lost my mom in October, and he's been the only person, despite what has happened, he has helped me. And I believe he will do better. If no drinking, I believe he can change his life. I already talked to the church. They already said that they're going to find him a job at the job fair April 25th if he does get out. And that's just what we're doing at this point. I don't want to raise my baby without my boyfriend. And it's kind of sad because I have nobody right now.
Thank you for being here this morning, Ms. Williamson. I'm sorry for your loss.
Thank you.
Yes, Ms. Rosenhuber.
Thank you, Judge. Mr. Hooper is 32 years old. He is a lifelong Georgia resident, grew up in Decatur, Georgia. His entire family does also reside here. He does share a child with Miss Williamson, and he earned his GED in 2015. Most recently, he was working at the Jiffy Lube for about 3 months prior to his incarceration. And before that job, he did have a job working at a restaurant. Your Honor, he is currently being held in a no bond status on a violation of probation. The state is correct about that. He does have a hearing set on the 17th. So while we understand that any bond reduction wouldn't mean Mr. Hooper's immediate release, he is unable to afford that $3,000 bond as it is currently set. And just to confirm, Judge, Miss Williamson did send me a copy of the affidavit. I sent that over to Miss Evans Battle. The request to have the bond hearing came both from Mr. Hooper as well as from Miss Williamson. And Judge, at this time, we're requesting a signature bond through pretrial for these particular charges. Thank you.
Okay. The court is concerned that he is not following the bond that he is currently on. So, Mr. Hooper, had you not violated the terms, that might be one thing, but given that another judge has already told you that you can have no contact at the present time, put your hand down. Go ahead and put your hand down. No contact at the present time. No contact means absolutely no contact. So I can't be assured that you're not going to continue to violate that until the right way to do it is to ask for a modification of the bond, which is what you're doing today. You should have done that before you violated the bond previously. Given his history, given the violation already, I'm going to leave the bond where it is at this time. If you want to petition again once he deals with the probation violation, then the court would be happy to rehear the matter. All right. Good luck to you, Mr. Hooper.
Understood, Your Honor. And I understand that he is raising his hand. Mr. Hooper, I would advise you not to speak. This meeting is, or this call is being recorded. But Judge, I do think we should briefly address, I think that this is a waiver and a not guilty. I don't believe this needs to be reset to another SAP calendar, but I just wanted to state that announcement for the record.
All right. Your case will be returned to the division judge, Mr. Hooper. Again, you have a right to remain silent. Anything you say can be used against you, Mr. Hooper.
Okay.
All right. Good luck to you, sir.
All right. All right, number 40, Mr. Howard.
Also, is this a plea, Ms. Rosenham?
Yes, Your Honor. Mr. White did send me a text that Mr. Howard wanted to speak with me. So, as far as I know, it's a negotiated plea. Mr. Howard, could you confirm, do you still wish to plead guilty today?
Yes, ma'am.
Was that a no?
I think he said yes.
Okay. Okay, great. Then yes, Judge.
All right. Good morning, Mr. Howard. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, thank you, sir. Yes, Ms. Evans Battle.
Yes, Judge, our recommendation is for 12 months probation, serve 60 days, credit for time served, of course, balance probated. Complete an MHET, stay away from the Walmart at 844 Cleveland Avenue in East Point. Stipulate to identity, venue, and a factual basis for the plea. Thank you.
Ms. Rosenhuber?
Thank you, Judge. We do so stipulate Mr. Howard has been in custody now for the past 17 days, and he does have a felony matter that is going to hold him in custody until that is resolved. He does have a hearing date set for that on April 23rd. Your Honor, we would just ask that after he does complete the mental health evaluation and follows the recommended treatment, that probation be allowed to go non-reporting. Thank you.
I understand 001877C, you wish to plead guilty to criminal trespass, is that right? Are you under the influence of any drugs or alcohol this morning?
Your Honor.
You've been represented by counsel. Are you satisfied with her representation?
Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Howard. When you complete the terms, I'll have it go to a non-reporting status. Good luck to you, sir.
All right, thank you, sir.
Yes, sir.
Come on. Item 53, Mr. Rowland.
What are we doing with Mr. Rowland this morning, counsel?
Your Honor, I think we're gonna proceed with the plea negotiation.
Okay, good morning, Mr. Rowland. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Yes, Ms. Evans Battle.
Yes, the state's recommendation is for 12 months probation, serve 72 days, credit for time served, balance probated, stay away from the 1305 Lanier Avenue, complete 40 hours of community service, stipulate to identity, venue, and a factual basis for the plea. Thank you.
Mr. Mergler?
Yes, Your Honor, we're amenable to those terms that we would like to waive the first couple months of probation fees to help him get back on his feet. That's all.
Mr. Rowland, it's my understanding that in case 26 CR 002086J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
I understand.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Rowland. I will waive 2 months of probation fees to help you get on your feet and get that 40 hours of community service done. Once you complete the terms of the probation, I'll have it go to a non-reporting status.
Thank you, sir.
You're welcome. Good luck to you, sir.
With the 61, Mr. Thomas.
Thank you.
What are we doing with Mr. Thomas this morning?
We are. He is going to be, we're going to ask him to be reset for 2 weeks, Your Honor.
Okay. Let's see.
Actually, I believe that we're.
So reset until April 21st.
Yes.
Okay.
One.
We'll see you back in 2 weeks, Mr. Thomas.
All right, have a good one.
Yes, sir.
And we would like to see you. Works program. Thomas, Finland Thomas.
64, Mr. Zachary.
60.
Zachary.
What are we doing with Mr. Zachary this morning?
Mr. Zachary feels that the ask for 90 days to stir is quite heavy-handed. He is amenable to less time, but if the 90 days is going to stand, then we would most likely proceed with a not guilty today and move the trial.
Okay. Ms. Hutcherson, may I get the history, please?
Give me 1 moment to pull it up.
So somebody tell me how long he's already been in custody?
Yes, he's been in about 15 days, Your Honor. And I will say that this allegation stems from a misunderstanding of a total MARTA stay away. And there were some issues with his involvement with the officer that has left him feeling that this is overblown. And so that's how we asking for less time.
Judge, are you ready for me to start?
Yes, Ms. Hutcherson.
49 cycles, a September of 2025 conviction for forgery in the 3rd degree, probation violation from 2023, a FTA from 2021, a DUI conviction from 2021, criminal trespass conviction from 2019, another criminal trespass conviction from 2019, a simple battery against a person who was 65 years or older conviction, 2016. A battery family violence conviction, 2015. A simple battery conviction and battery family violence conviction, 2011. A violation of a family violence order conviction, 2013. A aggravated battery conviction in 2007. A battery family violence conviction in 2005. 1 moment. And a simple battery conviction in 2005, and nothing further to add.
Thank you. Ms. Evans-Battle?
Yes, Your Honor. This happened March the 24th of 2026. The officers were patrolling MARTA Ashby Station. They were on the platform westbound. They noticed him. They indicated that he fit the description of a bolo that had been put out for someone in reference to a battery. They approached him and explained to him why he was being stopped. They did ask him to place his hands behind his back. He was handcuffed. He was transported to Central Precinct, and there they looked at his identification and conducted a search that indicated that he didn't have any active warrants, but he did have an active permanent ban that was issued May the 11th of 2024, effective June the 10th of 2024 for a certain nature type of assault. And so they determined that the bolo that was out for him, he had already gone to court on. But because of the permanent ban, he was given the criminal trespass charge in this particular case. So that is what happened.
Your Honor, we're a bit skeptical about the nature of this bolo, especially since my client says that the officers were calling him by name at the time that he was called over to them. So it would be hard to mistake him for someone else if they were calling him by name. And he said that he has had multiple interactions with these officers. They know who he is. He knows who they are. We're very dubious as this bolo claim and the initial probable cause for the stop.
But they're saying that he actually went to court already for the charge in which the bolo was out for. So it's just a bad bolo. I mean, he'd already gone to court for the case.
Yeah.
Ms. Evans Battle, I don't believe you put the recommendation on the record.
It's for 90 days credit for time served, balance probated. Stay away from all MARTA and compliance with the suspension or permanent ban that's already in place.
Okay. Mr. Mergler?
Yes, Your Honor. Were you asking for my commentary on that?
Yes. Anything further?
No, sir. We'll just raise again that he's amenable to less time served, but otherwise we're probably going to proceed with a not guilty today.
Okay. So he's been in custody for 15 days is what you're telling me?
Yes, sir.
All right. And Mr. Zachary, you understand that you cannot go back to MARTA?
I know.
Okay. You have a permanent ban for MARTA, so you cannot be at MARTA. I think that do you have something further, Mr. Evans, Ms. Evans Battle? Okay.
Who do I need to talk to? That's what I asking. Like,
Okay. So I think 15 days in custody is sufficient for this criminal trespass. So if he wishes to plead guilty, the court sentence is going to be 12 months to serve 15 days, credit for time served 15 days, balance suspended.
Yes.
We will take that, Your Honor. Thank you.
Okay. Mr. Zachary, it's my understanding that does he need to speak with you about something else, counsel?
Your Honor, he was just asking for some sort of physical paper, if we can, that talks about the MARTA stay away.
Yeah,
He just wants it to be presented with some sort of
Because they never
notice
told me that.
of that.
I don't know, like, as of now that you're telling me, I would have never went.
But
I've never been.
you're being told now.
Okay.
Yeah.
Okay.
All right. So Mr. Zachary, it's my understanding that in case 26 CR 001967B, you wish to plead guilty to criminal trespass. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
Also, I'm not.
You've been represented by counsel. Are you satisfied with his representation? You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
I do.
Has anyone forced or coerced you to plead guilty? And I will accept your plea, Mr. Zachary. The court sentence will be 12 months to serve 15 days, credit for time served 15 days, balance suspended, stay away from MARTA in compliance with your permanent ban, okay?
I understand.
All right, good luck to you, sir.
59, Mr. Circuit.
Come on, Dad.
Real quick, Your Honor.
Yes.
Quick, Your Honor. Mr. Zachary, due to his housing situation, he's just asked me if we could waive some of the fees at the beginning of his probation.
Not on probation.
Oh, he's not on probation. Oh, I'm sorry, I missed that. My bad. Thank you.
You calling me? Which one?
You call him? I just hear you call.
And what are we doing? What are we doing with Mr. Scarrett this morning?
Your Honor, could we, can I ask Ms. Evans Battle to please put the recommendation on the record? I think there might have been an error on this one. and I did not see.
Okay, Ms. Evans Battle, if you'll put the recommendation on the record for the court.
Twelve months probation. Wow. Credit for time served, balance, probated, whatever that is. Complete an ADET, 40 hours of community service. Stay away from the Georgian Terrace Hotel at 659 Peachtree Street Northeast.
Okay, that does. We are in agreement. Okay. Yeah, so we will go forward with the plea, Your Honor.
Hey, good morning, Mr. Scarrett. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Say it one more time. Okay, thank you. You can place your hand down. Anything further, Ms. Evans Battle?
No, sir.
Okay, Mr. Mergler?
We're good on our, we so stipulate.
Okay. Mr. Scarrett, it's my understanding that in case 26 CR 001955Y, you wish to plead guilty to criminal trespass, is that right?
Sure.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation? Say it again for me. Still can't hear you.
Sir.
Yeah. You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right.
Sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Does he have any housing necessities? Mr. Mergler, does he need a social worker visit or to assist with housing?
Would like to speak with a social worker.
Okay, so we'll get you some assistance with housing. I'm going to waive your probation fees while you're on probation, so that you can get on your feet. And once you complete the terms of the probation, I'll have it go to a non-reporting status. Just make sure you don't go back to that Georgian Terrace. So Hope Patel. You understand?
Yes, sir.
All right. Good luck to you, sir.
All right. Now we'll go to 13, Mr. Brown.
What are we doing with Mr. Brown this morning?
We negotiated plea, Judge.
Thank you. Good morning, Mr. Brownlee. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Evans Battle.
Yes, the recommendation is as to count one, the state would move to null pros that case. As to count two, 34, serve 34 days credit for time served, balance probated, complete the Operation 21 law and decision making, 40 hours of community service, no alcohol, drugs, or weapons. He cannot possess any firearms during the probationary period. 12 months probation, a fine in the amount of $300 to run concurrent with count two. This is a continuous reporting probation. We ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you.
So, Judge, we do stipulate for the purpose of the plea. We would ask to waive the first 2 months of probation fees and convert his $300 fine to an additional 30 hours of community service, and ask that his probation terminate once he completes all of his requirements.
Ms. Evans Battle just asked for continuous reporting.
Yes, this was a transfer down for possession, theft by receiving of a firearm case. So we're asking that this 1 year probation be reporting probation.
Obviously wasn't a valid charge, or it wouldn't be here, Judge. It's still theft by receiving and false info. So I mean, we'll leave it up to you, Your Honor, but we're asking for it to go non-reporting or terminate once he completes his requirements.
Okay. Mr. Brownlee, it's my understanding that in case 26 CR 001933A, you wish to plead guilty to theft by receiving stolen property and giving false information to law enforcement. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Brownlee. I will waive the first 2 months of your probation fees to help you get on your feet. I will convert the $300 fine to 30 hours of community service. When you complete the terms of the probation, I'll have it go to a non-reporting status. You'll still be on probation, but you won't have to report once you successfully complete the terms. Good luck to you, sir.
Thank you,
Are we going to have Mr. Burton add on 4 this morning?
Let me double check. You don't have anything else? You gotta do a double count.
Did Mr. Burton
Oh, we did?
case on the regular calendar? So we do both of them together.
Oh, we did. Okay, thank you.
14 on the regular calendar.
Thank you. So that should take care of everyone this morning, correct?
Yes, sir.
All right, very good. Thank you all. Let's see, Ms. Champion, whenever you're ready for us.
Excuse me, I have something to say.
I'm sorry, who's speaking?
This is Shanice Grady. I was on the case for Mark when he supposed to be in court this morning.
What's the
This
last
I got
name?
Williams. Because I talked to a lady
Mr.
called me.
Yeah,
A lady
Mark.
had called me.
Okay, yes, ma'am.
Yes, sir. Go ahead. You can go ahead, sir.
Is Mark Williams, is that who you're here for?
Yes, sir.
Okay, that case has been reset until the 21st of this month, ma'am. So
Okay,
you,
thank
yeah, yes, ma'am. So you're welcome to come back at that time, okay?
at 9.
Yes, ma'am.
Okay, thank you, Judge.
You're welcome. You have a good day now.
You do as well. Thank you.
Your Honor, I don't know if I had stated with Mr. Blaylock that I would be waiving arraignment and I would like his case to be placed on the next available jail calendar.
Okay. So that's position number 5.
That is correct, Your Honor.
Okay. Thank you. If nothing further, before we go over the calendar, Ms. Champion, whenever you're ready.
Your Honor, I'm sorry, briefly, can we readdress Marion Johnson on the calendar? And I'm gonna turn it over to Ms. Wood.
Yes, Your Honor. I got a little flustered earlier myself, and with the bond being higher than expected, I do think I'd like to ask for a bond, or renegotiate his bond with a hearing now. Is that something you're open to?
Okay, so is Mr. Johnson in the courtroom?
He's not here. We've asked him to be brought back, and hopefully.
And Judge, basically the issue was, our notes indicated that he only had a $2,000 bond. We weren't aware of the Afraid case, I believe, where the $1,000 bond is. So he made his decision based on the fact that he could make that $2,000 bond. We were just wondering if we can somehow or another work this to where it's a $2,000 bond instead of 3.
Thank you.
Okay, so while we're waiting for him, what is the bond, position 21, what is the current bond on the criminal trespass and Afraid?
I think it's a different position, Your Honor. I think it's gonna be 40 something.
41.
41, 41.
Right, Marion Johnson?
That's correct.
Okay, so position 41 with Marion Johnson, I have on my calendar criminal trespass and affray. On that, and on position 42, I have a disorderly conduct.
Yes, that's correct.
Okay, so my question, go ahead.
I was just gonna say, we were under the impression that it was a $2,000 cash bond for the criminal trespass and the affray and, well, the whole thing, actually, Your Honor. We thought that was the total bond amount.
Okay, and my question was, I need to get a clarification. What is the bond on the criminal trespass and affray? Ms. Evans Battle? Do you have, can somebody pull up the bond order for me, please?
I'll have to pull up the actual order because I have it as a pretrial release. So
Oh, and this is also a failure to appear.
Yes.
Yes.
Failure to appear. You know, my normal practice, well, you might not know, Mr. Mergler, but my normal practice is if another judge has, if there was a failure to appear and another judge issued that bond, I send it back to the other judge to decide whether they want to lower that bond or not.
Understood.
Okay. So is there a problem, Ms. Evans Battle?
yes, I know I'm making the face. I know.
What's that?
I said I know I'm making the face.
Well, it was more the groan than anything else.
I didn't realize that you could hear me. Okay,
So
the
Mr. Johnson's case is gonna be returned to the division judge since it's a failure to appear.
Okay, then.
I see.
All right.
You may get a better offer.
So just
go ahead.
Okay, Your Honor. Given that that's your policy and I totally understand, we'll go ahead and waive that and try to renegotiate with the other judge.
Okay, and it'll go back to the division judge so they can make the determination.
Perfect.
All right.
Thanks
If nothing further, Ms. Champion.
We did have the I just sent over some for Mr. Bonner, who is actually on our calendar. It's a felony transfer, and I just sent the documents over to ask the court to sign those transfer orders.
Okay, thank you. Ms. Champion will get those to me with all the other orders.
Okay. Position number 1 is going to be reset further notice jail jury with a bond of $5,300 good bond. Position number 2 was a plea. Position number 3 was a plea. Position number 4 was a plea. Position number 5 is reset further notice jail jury with the amended bond of a $5,000 good bond. Position 6, 7, 8 will be transferred to Superior Court. And position number 9, which is the failure to appear, will you be null pros in the failure to appear, Ms. Battle? Okay, that will be null pros. Position number 10 is going to be reset SAP 421. Position number 11 was a plea. Position number 12 was a null pros. Position number 13 was a plea. Position number 14 was a plea. Position 15, 16, 17, 18, and 19, and 20 was reset for the notice, defendant release. Position number 21 is reset to the SAP competency calendar 423. That's also the announcement for 22 and 23. 24 was a plea. 25 was a plea. 26 was a null pros. 27 was a plea. 28 was a null pros. 29 was a plea. 30 was a plea. 31 was a plea. 32 and 33 were null pros. 34 was a plea. 35 is going to be reset to the SAP 414. 36 was a plea. 37 was a plea. 38 was a null pros. 39 is going to be reset further notice jail jury. 40 was a plea. 41, 42, and 43 will be reset further notice jail jury. And 44 reset further notice jail jury. 45 was a plea. 46 was a no pros. 47 is reset further notice jail jury. 48 is reset further notice jail jury. 49 is reset further notice jail jury. 50 and 51 is reset further notice jail jury. 52 was a plea. 53 was a plea. 54 was a plea. 55 was a plea. 56 was a plea. 57 was a plea. 58 is reset to the SAP 414. 59 was a plea. 60 is reset SAP 421. 61 is reset SAP 421. 62 and 62 was reset further notice defender release. 63 was reset SAP 421. 64 was a plea. Add-on 1 is going to be reset to the SAP Competency Calendar 423. Add-on 2 and 3 is reset to the SAP Competency Calendar 423. 4. Any questions?
Okay, if no questions, thank you all. Good to see everyone. I'll see you next Tuesday. Y'all have a good rest of your week.
Have a good one. Bye.
Thank you, Judge.
So, yeah, when you're, well, you know how to fill them out, right? Yeah, but
Yes, I've never done it before, so I don't.
okay, just
want to make an error.
all right. Okay.
And I believe it's all.
Right, so you got waivers and guilty pleas, is that correct?
Okay, so.
It's waivers, really straightforward.
That's a waiver.
It's a waiver of hearings and arraignment. Right. So you don't have to bring them if you waive the case. You just, you're not guilty plea, you can just put waiver on there and then they won't bring it down.
I see.
Yeah, because you're waiving both of your parents. Or the